Hi friends, good morning. This is Dr. Harinath Reddy, Director, Bhavishya IAS Academy. In today's lecture, we will discuss the salient features of Indian Constitution. In today's lecture, we will discuss the salient features of Indian Constitution. So we will begin with supremacy of Indian Constitution. See, Indian Constitution is written, and in India, the Constitution is supreme. In India, the Constitution is supreme. See, all the three branches of the government, the executive branch, legislative branch, and the judicial branches, they derive their authority from the Constitution of India. And the supremacy of Indian Constitution is protected and guaranteed by an independent judiciary with the power of judicial review. An independent judiciary with power of judicial review. So Indian Supreme Court is entrusted with the task of acting as the final interpreter and protector of Indian Constitution. So in this respect, Indian Constitution differs with that of the Constitution of United Kingdom. See, the Constitution of United Kingdom, it is mostly unwritten. So that's why in United Kingdom, it is not the Constitution which is supreme. It is the British Parliament which is supreme. So it was very humorously said that in Britain, the British Parliament can do anything except converting a man into woman and a woman into a man. So that is the supremacy of the British Parliament. British Parliament, sovereign, supreme in Britain. See, among all the three branches of the government in Britain, the executive branch, which includes British Prime Minister and the British Cabinet, the legislative branch, which includes British Parliament, and the judicial branch, which includes the Supreme Court of United Kingdom. Among all the three branches, it is the Parliament which is supreme. So, Constitution of Britain provides for parliamentary supremacy. On the contrary, Indian Constitution provides for supremacy of the Indian Constitution. Supremacy of the Indian Constitution. In India, the Constitution is supreme. In Britain, Parliament is supreme. The reason Indian Constitution is written, the British Constitution is unwritten. So that's why we say that in India, Constitution is supreme because it is written. In Britain, the Parliament is supreme because the Constitution is unwritten. This is one salient feature of Indian Constitution. In addition, Indian Constitution is the bulkiest written constitution. Remember, Constitution of United States of America is the first written constitution, but among the written constitutions, Constitution of India is the lengthiest written constitution. It is the bulkiest written constitution. And what are the reasons why the Constitution of India became very bulky? The reasons are, unlike in classical federations like in United States of America, in United States of America there are 50 states. Each state has got its own constitution. And for the entire federation there is one federal constitution. But unlike in United States of America, in India, the constitution for the central government and the constitution for the states is one and the same. So we have one single constitution for the center as well as the states. In addition to this, the framers of the Indian Constitution have included even minor administrative details which are otherwise left to the legislative branch of the government to be decided as and when the situation arises. In addition to this, the geographical size of India, and then the safeguards to protect the interests of certain disadvantaged social groups made Indian Constitution the bulkiest written constitution. So this is the second important salient feature of Indian Constitution. So Indian Constitution, among the written constitutions, it is the bulkiest written constitution, it is the lengthiest written constitution. And then the third one, Indian Constitution, it is neither completely rigid nor completely flexible. Indian Constitution, it is neither completely rigid nor completely flexible. See, remember, this is one of the salient features of the Indian Constitution. It was very much appreciated by even a British constitutional expert by name Granville Austin. So Granville Austin says the amendment procedure which is prescribed for Indian Constitution is unique in the sense it is a mix of rigidity and flexibility. But if you compare Indian Constitution with that of United States of America, the Constitution of United States of America is the most rigid constitutions across the world. The reason is, why do we say that American Constitution is very rigid constitution? In America, any amendment to the federal constitution requires not only the approval of the parliament, American parliament, that is American Congress, even 3/4 states in America must also give approval for the constitutional amendment bill. So a bill which is meant for amending the federal constitution of United States of America, it has to be passed by both houses in the American parliament by special majority. In addition to this, 3/4 out of 50 states in America must also give their approval. So that's why the Constitution of America is the most rigid constitution. It's very clear if you look into the number of amendments which were done to the American Constitution in the last more than 220 years. See, remember the American Constitution came into implementation in the year 1789. The American Constitution came into implementation in the year 1789. From then till now, in the last more than 220 years, the Constitution of America is amended hardly 26 times. So this itself speaks about volumes about the rigidity of the American Constitution. Unlike American Constitution, Indian Constitution from 1950 till today, in the last more than 6 decades, it was amended more than 100 times. So if Indian Constitution was to be rigid, it's not possible to have more than 100 amendments in a span of just 65 to 70 years. And the most recent amendment being the GST, Goods and Services Tax. 101 Constitutional Amendment Act is the most recent amendment to the Indian Constitution, which provided for the replacement of indirect taxes of the central and state governments with one tax, GST, Goods and Services Tax. So that's why we say that in terms of rigidity and flexibility, the Indian Constitution, it is a blend. It is a mix of rigidity and flexibility. Remember, it's more flexible than rigid. Most of the provisions of the Indian Constitution can be amended by the Parliament alone without the participation of the state governments through simple majority. This is one way of amending the Indian Constitution. Most of the provisions of the Indian Constitution can be amended by the Indian Parliament unilaterally without the participation of the state governments by simple majority. So in this respect, we say Indian Constitution is more flexible. Then there are certain features of the Indian Constitution like the fundamental rights and directive principles of state policy. They can be amended by the Indian Parliament unilaterally but with a special majority, a combination of absolute majority plus 2/3 of the members present and voting. With this majority, Lok Sabha and Rajya Sabha can make amendments to the fundamental rights and the directive principles of state policy. Here again, the participation of the state governments is not required. And the third way of amending the Indian Constitution is by the Parliament as well as the state governments together. So there are certain features in the Indian Constitution which are called federal features. The federal features of the Indian Constitution, under Article 368 of the Indian Constitution, they need approval by the Parliament by special majority, and more than half of the state legislatures must also agree by simple majority. In other words, the federal features of the Indian Constitution can be amended by the Parliament with special majority, and even approval of half of the state legislatures with a simple majority is required. The very good example is the recent 101 Constitutional Amendment Act relating to GST. So this constitutional amendment bill is passed by the Parliament, Lok Sabha and Rajya Sabha with a special majority. In addition, more than half of the state legislatures also gave their approval by simple majority. So these are three ways of amending the Constitution of India. Federal provisions, they are not, it forms only a small part of the Indian Constitution that needs special majority in the Parliament and approval of the state legislature. So that part of the Constitution, amending that part of the Constitution is a bit difficult, so we say rigid. So in other words, the Constitution of India is a blend, it is a mix of rigidity and flexibility. It's more flexible than rigid. That's the third important feature of Indian Constitution. See, remember under Article 368, under Article 368 of the Indian Constitution, Indian Parliament can amend the provisions of the Indian Constitution. Remember from 26th January 1950 up to 24th April 1973. From 26th January 1950 up to 24th April 1973, the power of the Indian Parliament to amend the Constitution under Article 368 is unlimited. It is absolute, which means any provision of the Indian Constitution can be amended by the Indian Parliament under Article 368. But on 24th April 1973, in one of the cases decided by the Indian Supreme Court, which is called Keshavananda Bharati case. See, Keshavananda Bharati case was decided by the biggest bench ever constituted in India. Keshavananda Bharati case was decided by a bench consisting of 13 judges. Keshavananda Bharati case was decided by a bench consisting of 13 judges by a majority of 7/6. So on 24th April 1973, in Keshavananda Bharati case, a 13-judge bench of the Indian Supreme Court said that all the provisions of the Indian Constitution, they don't have equal importance. There are certain features of the Indian Constitution which are very fundamental, which are very basic, which are very essential. So the amendment of the basic features of the Indian Constitution, the fundamental features of the Indian Constitution, the essential features of the Indian Constitution cannot be done by the Indian Parliament. So under Article 368, Indian Parliament cannot amend the basic features of the Indian Constitution. What are the basic features of the Indian Constitution? For example, the Indian Supreme Court from time to time has held the following as basic features of the Indian Constitution: independence of judiciary, rule of law, secularism, federalism, separation of powers, balance among all the three branches of the government, free and fair elections, parliamentary democracy. So these were considered to be the basic features of the Indian Constitution by the Indian Supreme Court. So in other words, on 24th April 1973, the Indian Supreme Court, through its judgment in Keshavananda Bharati case, has made unlimited power of the Indian Parliament to amend the Indian Constitution into a limited power. And this is called the doctrine of basic structure. Remember, doctrine of basic structure doesn't have any constitutional sanctity. Neither in the Constituent Assembly nor anywhere in the Constitution of India there is reference to doctrine of basic structure. Doctrine of basic structure is an innovation made by the Indian Supreme Court. It is a creation of the Indian Supreme Court. So Indian Supreme Court, by coining the term doctrine of basic structure, has took away the legitimate powers of the Indian Parliament to amend any provision of the Indian Constitution. So that's one important point which we need to remember when we discuss the procedure for amending the Constitution of India. I told you that Indian Constitution can be amended both easily as well as with difficulty. The amendment process is a blend of rigidity and flexibility. But in 1973, one more concept is added called the doctrine of basic structure. This doctrine of basic structure says the power of the Indian Parliament to amend the Constitution under Article 368 is limited. It cannot amend every feature of the Indian Constitution. Especially the basic features of the Indian Constitution are beyond the power of the Indian Parliament to amend the Constitution. So that's one important point, the third salient feature. Then rule of law. See, the Indian constitution is based on the bedrock principle of rule of law. See, rule of law is a concept which was given in Britain by a political thinker called A.V. Dicey. According to rule of law, every person has to be treated equally. There can't be privileges for certain categories of the people. There cannot be arbitrariness on the part of the government. And this is very much necessary for protecting the freedoms, rights and liberties of the people. And this rule of law will be enforced by the Indian Supreme Court and the High Courts through their power of judicial review. So the concept of rule of law was also declared as a basic feature of the Indian Constitution by the Indian Supreme Court. Rule of law includes exclusion of arbitrariness, exclusion of unreasonableness, principle of equality to be followed. The rights and liberties of the citizen are protected. And this can be done by the Indian judiciary through its power of judicial review. So it is the law which is supreme, not the individual who is supreme. The law rules. That is the concept of rule of law. So Indian constitution is based on the principle of rule of law. And this rule of law is declared as one of the basic features of the Indian constitution by the Indian Supreme Court. Then, in addition to this, Indian constitution is federal constitution, but there is a difference. See, if you compare Indian constitution with American constitution, Indian constitution is federal, American constitution is also federal, but there is a fundamental difference. The difference is, the American constitution is a classical federation. In America, the federal constitution is the result of agreements among the states. But in India, the Indian constitution became federal for administrative convenience. And it is not the result of agreement among the states. So that's why in America, the states are very powerful. The center is relatively weak. The American federal constitution provides for strong states, a relatively weak center. But on the contrary, the framers of the Indian constitution provided for a federal constitution to India in which the center is strong, the states are relatively weak. So why did we deviate from the American constitution? The reason is, if you remember at the time of partition, in the name of religion because of communal rights, 10 lakh people got killed because of communal rights. In addition, more than 1 lakh women were abducted from both sides. And this is what is there in the minds of the framers of the Indian Constitution. Threat to the unity and integrity of India. And remember, when the Indian Constitution was getting drafted, many Western scholars, they said that India is a land of huge diversity. India will not continue as one nation for long. It will break up into several Indias very soon because of this enormous diversity. So the framers of the Indian Constitution were greatly worried about protecting the unity and integrity of India. They felt in their wisdom that if the central government is made strong, unity and integrity of India can be protected. That's why we deviated from the American Constitution. So Indian Constitution became federal, no doubt, but the center is strong. The states are relatively weak. The objective of having a federal constitution with a strong center and a relatively weak states is to protect the unity and integrity of India. See, 7th schedule of Indian Constitution under Article 246 divides executive powers, legislative powers and financial powers between the central government and the state governments. So in the executive sphere, in the legislative sphere and even in the financial sphere, the central government is made more powerful at the cost of the state governments. The reason is to ensure that the central government is sufficiently strong to protect the unity and integrity of India. In addition to this, the American Constitution provides for indestructible union with the indestructible states. What do you mean by indestructible union? The 50 states in America, they do not have the right to break away from American Federation. Even the American Supreme Court, remember, the American Constitution is silent on the issue whether the states have the right to secede, to break away from the Federation. But It was clarified by the American Supreme Court after the American Civil War in 1861 to 65 that the states in America do not have the right to break away from the federation. So, indestructible union. Indestructible union means the American Federation is indestructible. The states in America do not have the right to break away from American Federation. Same is the case with India. Even Indian Union is indestructible. The states in India do not have the right to break away from Indian Union. This is the similarity. But there is a difference. The difference is, in America, the states are indestructible. The territorial integrity of the states is guaranteed by the American Federal Constitution, which means if the boundaries of the states have to be altered in America, consent of the concerned state legislature is compulsory. But in India, the boundaries of the states can be altered by the Indian Parliament unilaterally without the consent of the concerned state legislature by simple majority. So we say Indian Constitution provides for indestructible union with destructible states. States can be reorganized. The boundaries of the states can be altered by the Indian Parliament by simple majority even without the consent of the state legislature. That's why we say Indian Constitution provides for indestructible union with destructible states. The territorial integrity of the state governments is not guaranteed. But in America, the American Federal Constitution provides for indestructible union with indestructible states. The territorial integrity of the states in America is guaranteed. Only with the consent of the concerned state legislature, the boundaries of the states can be altered. So the reason why I compare Indian Constitution with other countries is so that you will better remember the things and you will better appreciate what is being taught. That's the reason. So this is the fifth salient feature. Indian Constitution is federal, and Indian Federal Constitution provides for a strong center and relatively weak states. Remember, unlike American Constitution is a two-tiered federation. American Constitution is a two-tiered federation, which means in America the federal government and the state governments have constitutional recognition. But in India, there is constitutional recognition not only for the central government, not only for the state governments, but even for the local governments. 73rd Amendment to the Indian Constitution, 1992, conferred constitutional recognition to Panchayati Raj institutions. 74th Amendment to the Indian Constitution, 1992, conferred constitutional recognition to urban local governments. Remember, Article 246 under 7th schedule divides the powers between the central government and state government. 11th schedule under Article 243 capital G. 11th schedule under Article 243 capital G divides the powers between the state governments and Panchayati Raj institutions. 12th schedule under Article 243W. 12th schedule under Article 243W divides the powers between the state governments and urban local governments. So there is a division of powers not only between the center and the states. There is division of power between the state and local governments. And in addition, the central government, the state governments and the local governments, they have got constitutional recognition in India. So that's why we say Indian Federal Constitution is a three-tiered. There are three levels of governments recognized by the Constitution. So the other examples include Switzerland, Nepal. So even Switzerland, under the Constitution of Switzerland, there is constitutional recognition to three levels of government: central government, cantonal government or provincial government, and the local government. Even in Nepal, the recent Constitution of Nepal provided for a three-tiered federation, three levels of government having constitutional recognition. So Indian Constitution is a three-tiered federation, three levels of government recognized by the Constitution. But the problem is, the 29 items in the 11th schedule, 18 items in the 12th schedule, which are given to the Panchayati Raj institutions and urban local governments respectively, it is not mandatory, it is not compulsory, it is left to the discretion of the state governments. the state governments may means may not be also. The state governments may devolve functions, finances, functionaries to the Panchayat Raj institutions with respect to 29 items in the 11th schedule. The state governments may devolve functions, finances and functionaries. Functionaries means bureaucracy to the urban local governments with respect to 18 items in the 12th schedule. So it is left to the discretion of the state governments. That's the difference. So American Constitution, two-tiered. Indian Constitution, three-tiered federation. So that is the fifth salient feature. Then, see, when there is any threat to the integrity and unity of India from either internal or external threat, Constitution of India provides for declaration of emergency. So when there is threat of armed rebellion, external aggression to India, under Article 352 of the Indian Constitution, the Indian President, on the advice of the Union Cabinet, headed by Prime Minister, can declare national emergency. So once emergency is declared, the Indian Federal Constitution becomes unitary. The center becomes all powerful. The state governments, they exist. The state legislatures, they exist. But they are completely subordinated to the national government. So in other words, this is again a very novel feature of the Indian Constitution. In times of emergency, Indian Constitution becomes federal. In normal times, Indian Constitution is... See, in times of emergency, Indian Constitution becomes unitary, and during normal times, Indian Constitution is federal. And this doesn't need any amendment to the Indian Constitution. Without any formal amendment to the Indian Constitution, in times of emergency, Indian Constitution becomes unitary to facilitate the national government to pull up the resources for protecting the unity and integrity of India. And during normal times, Indian Constitution works like federal. So without any formal amendment to the Indian Constitution, in times of emergency, Indian Constitution becomes unitary, where the national government becomes all powerful, and during normal times, Indian Constitution becomes federal, which means the states will be supreme in the areas which are assigned to them. That's one important feature. And then, Indian Constitution also provides for written fundamental rights. See, Part 3 of the Indian Constitution guarantees to every citizen of this country a set of rights called fundamental rights. Fundamental rights. So the concept of written fundamental rights we have borrowed from American Constitution. See, in American Constitution, the fundamental rights are called as Bill of Rights. So the concept of written fundamental rights in Indian Constitution were borrowed from American Constitution. The fundamental rights, they aim at political democracy, political equality among all the citizens, irrespective of gender, irrespective of religion, irrespective of ethnicity. All the citizens have the same right to vote. See, fundamental rights guaranteed by the Indian Constitution, they cannot be taken away by the Indian Parliament and state legislatures through ordinary law. So Indian Parliament and the state legislatures, by enacting ordinary laws, cannot take away fundamental rights. If the fundamental rights need to be amended, the Parliament can do so only by special majority under Article 368. So, and in addition, if the fundamental rights guaranteed by the Indian Constitution are taken away by the executive branch and the legislative branch, there is a remedy available to the citizen of this country. Under Article 32 of the Indian Constitution, a writ petition can be filed before the Indian Supreme Court for the enforcement of fundamental rights. What is writ petition? A writ petition is a petition asking the Supreme Court to give orders for enforcing the fundamental rights of the citizens. So if the fundamental rights guaranteed by the Indian Constitution are violated or taken away by the executive branch or the legislative branch, the citizen has a remedy before the Supreme Court, before the High Court. He can file writ petition. Under Article 32, a writ petition can be filed before the Supreme Court. Under Article 226, a writ petition can be filed before the High Court. The citizen can straightaway go before the Supreme Court or the High Court for enforcement of his or her fundamental rights. So this is again one important feature. So this is to ensure that the rights and liberties of the citizens are protected. The governments can become autocratic and dictatorial at some times. So fundamental rights, they act as a limitation on the executive branch, on the legislative branch. So fundamental rights, they act as a limitation on the executive branch and the legislative branch. But during emergency, the fundamental rights can be suspended for a temporary period. And remember, even during emergency, there are certain important fundamental rights guaranteed by Article 20 and Article 21. Fundamental rights guaranteed by Article 20 and 21 cannot be suspended even when national emergency is in operation. So that's one important feature which you should remember. Salient features. So fundamental rights, again, one important salient feature. See, you don't have this concept of written fundamental rights under British Constitution. So the Constitution of Britain, unwritten, so there are no written fundamental rights under the British Constitution. But under Indian Constitution, under American Constitution, fundamental rights are written. They are protected by the independent judiciary through the power of judicial review. Then, again, Indian Constitution is having again one unique and important salient feature in the form of directive principles of state policy. See, directive principles of state policy, they are positive obligations on the governments for creating welfare state, social, economic and political justice, equality of opportunity and equality of status. See, the directive principles of state policy, if they are not implemented, the citizen cannot have any remedy. He cannot go before the High Court and Supreme Court for the enforcement of directive principles of state policy. See, remember, directive principles of state policy, they deal with achieving social and economic democracy. Implementing directive principles of state policy need lot of money, resources. That's why they are made non-justiciable. See, fundamental rights are justiciable. That means if fundamental rights are violated, the citizen can go before the High Court and Supreme Court for having a remedy for enforcing the fundamental rights. And the directive principles of state policy, they are not justiciable. The reason is not because they are not important. They are much more important than fundamental rights. And so, to implement directive principles of state policy, the Indian state needs a lot of money, which is not available. That's why adequate time is given for the Indian state to implement the directive principles of state policy. So that's why they are made non-justiciable. But otherwise, the directive principles of state policy, they are positive obligations on the Indian state. What the Indian state has to do over a period of time, it is dictated by the directive principles of state policy. And they are very fundamental in the governance of the country. They help in achieving social, economic and political justice. They help in achieving equality of status and equality of opportunity. They help in realizing the goal of welfare state. So, directive principles of state policy. See, at one point of time, the Indian Supreme Court said that fundamental rights are more important than directive principles of state policy. Directive principles of state policy are subordinated to the fundamental rights. Champakam Dorairajan case. But in course of time, especially in Keshavananda Bharati case and Minerva Mills case, Indian Supreme Court said the balance between the fundamental rights and directive principles of state policy is a basic feature, which means the balance between the fundamental rights and directive principles of state policy cannot be amended even by the Indian Parliament under Article 368. So in Minerva Mills case in 1980, Indian Supreme Court said the balance and harmony between fundamental rights and directive principles of state policy is a basic feature. In other words, over a period of time, the Indian Supreme Court said both are equally important. And one British constitutional expert by name Granville Austin, he says that they are like the two wheels of a chariot. One without the other has no meaning. Fundamental rights and directive principles of state policy together constitute the conscience of Indian Constitution, the soul of Indian Constitution. They are very important parts of Indian Constitution. So that's about the directive principles of state policy. Then parliamentary democracy. See, Indian constitution provides for the establishment of parliamentary democracy. Remember, India was ruled by Britain for more than 2 decades. Initially under English East India Company, subsequently directly by the British Crown on the basis of the laws made by the British Parliament. See, Britain is the first country to experiment with the parliamentary democracy. Britain is the first country to experiment with the parliamentary democracy. British Parliament is called mother of all the parliaments across the globe. So when India, before independence, when India was under the British rule, the Britishers have introduced a parliamentary democracy in India and the parliamentary institutions in India. So the Indians got used to parliamentary democracy, and so we went in for a parliamentary democracy under the new constitution for independent India. See, Indian constitution provides for parliamentary democracy not just because we were used to parliamentary democracy. There are certain merits with parliamentary democracy. Remember, Indian constitution provides for parliamentary democracy, American constitution provides for presidential democracy. Then why did India choose parliamentary democracy? Why not presidential democracy? One reason is we are used to parliamentary democracy. That's not the only reason. The other reason is, remember, parliamentary democracy is much more accountable than presidential democracy. Remember, in parliamentary democracy, one important principle is fusion of executive and legislative branches. There is overlap between the executive and legislative branches. For example, in India, the Prime Minister and Minister, they shall be members of Parliament. At the state level, the Chief Minister and the Council of Ministers, they shall be members of state legislature. In other words, a political party or a group of political parties which get absolute majority in the lower house will form the executive branch. In other words, the executive branch is drawn from the legislature and the executive branch is accountable to the legislature. Remember, in India, the parliament meets 3 times in a year: budget session, monsoon session, winter session. Every time the parliament meets, the prime minister and ministers, they are present in the parliament. The members of the parliament can ask questions to the prime minister and ministers in the question hour, in the 0 hour, and can make the government continuously accountable to the people. So question hour, 0 hour, they were important tools in the hands of the parliament to control the executive branch. So that's why parliamentary democracy we chose as a better form of democracy compared to presidential democracy. The reason is parliamentary democracy is much more accountable because the executive is drawn from the legislature. The executive is accountable to the legislature. And if the executive is not performing well, the executive can be taken away, removed by passing a no confidence motion. If you take presidential democracy in United States of America, the president and his cabinet, they shall not be members of the American parliament. The American president cannot be removed by the American parliament by passing a no confidence motion. The American president cannot dissolve the American parliament, that is the lower house of the American parliament, House of Representatives. So the American presidential democracy is based on complete theory of separation of powers. So there is a separation of executive and legislative branches in presidential democracy, but there is a fusion of executive and legislative branches under parliamentary democracy. So before the framers of the Indian Constitution, there were 2 options. One is to go for a presidential democracy. The advantage and the merit of presidential democracy is more stable. There is a fixed tenure for the executive branch. Within the fixed tenure, the executive cannot be removed by passing no confidence motion. So the beauty and the merit of presidential democracy is the stability of the executive branch. But the beauty of parliamentary democracy, accountability. So we have to choose between stability and accountability. So finally the framers of the Indian Constitution felt that accountability is much more important than stability. So we chose parliamentary democracy because it is more accountable, if not more stable. So there are several reasons why India went in for a parliamentary democracy. One reason, we were used to parliamentary democracy. The second reason, it is much more accountable form of democracy. The third reason, See, in a presidential democracy, the entire executive power is conferred in one individual. For example, in America, the entire executive power is conferred on American president. But in a parliamentary democracy, the executive power is conferred on a group of persons called cabinet or the council of ministers. So the sharing of political power among different people belonging to different religions, different regions is possible in a parliamentary democracy. The prime minister can be from north, the ministers can be from different provinces, different states, different religions, different ethnicity, different castes. So in a parliamentary democracy, the executive and the political power is shared among a group of members called the council of ministers headed by the prime minister, the cabinet headed by prime minister. So it is possible to share political power among different groups, and so the diversity could be better accommodated in the cabinet, and so that is the advantage. So in the parliamentary democracy provides for cabinet system of government where the power is vested in the hands of the council of ministers headed by prime minister. So in the council of ministers, there is opportunity to give representation to the minorities, to the people from different states, different regions, different ethnicities. So these are the three reasons why India became a parliamentary democracy. The first reason, we were used to parliamentary democracy. The second reason, it is more accountable form of democracy. The third reason, the executive power is conferred in a group of individuals. Sharing of political power is possible. The diversity can be better accommodated. That's one more reason. So that's one important salient feature of Indian Constitution, parliamentary democracy. Parliamentary democracy. Then secularism. See, secularism. See, Indian Constitution provides for the establishment of a secular state, which means the Indian state, the Indian government doesn't have any official religion. All the religions are treated equally by the Indian state. And liberty of thought, expression, belief, faith and worship is guaranteed by the Indian Constitution. So every citizen has the fundamental right to freedom of conscience, freedom to profess, freedom to practice religion. So the state does not interfere in the matters of the religion. All the members of different religions, they are treated fairly, equally. The religious affairs are kept at distance from the secular matters of the state. So the Indian state keeps itself away from the affairs of the religion. The affairs of the religion. So that's the meaning of secularism. See, there is again two variants of secularism, Western model of secularism and Indian secularism. See, in the Western model of secularism, the state is irreligious. The state will not participate in religious activities. But in India, the state is religious, very much religious. So in countries like America, the state has to keep away from religion. It cannot promote, it cannot give aids to religions. But in India, the requirement is all the states have to be treated, all the religions have to be treated equally. If required, the Indian state can give grants to all the religions for the promotion of the religions. But while giving grants, there shall be no discrimination. So under the Indian model of secularism, the state is religious in the sense the state can participate in the affairs of the religion, the state can patronage religions, but all the religions have to be patronaged, promoted equally without any discrimination. So this is the difference between Western model of secularism and Indian model of secularism. Indian state very much religious, but all the religions are treated equally and fairly. No special patronage for any particular religion, no discrimination on the ground of religion. That is Indian model of secularism. In the Western model of secularism, the state is completely separated from the matters of religion. The state cannot aid any religion in the Western countries. So Indian constitution is secular. The reason why the Indian constitution is a secular constitution is to protect the rights of the minority community. So at the time of drafting Indian constitution, the minorities, they had fear and insecurity in their minds that they may not be treated equally and fairly. So to give a sense of security to the minority communities in India and to promote unity and integrity of India by giving a sense of security to the minority communities, the framers of the Indian Constitution provided for a secular constitution. It doesn't matter whether you are a minority community or a majority community. All the citizens are treated equally, irrespective of their religion. That is the meaning of secularism. So Indian Constitution became secular to promote unity and integrity of India by encouraging a sense of security in the minds of the minority communities. The minority communities are not put at a disadvantage. They are treated equally. They were guaranteed all the rights which are available in the Indian Constitution. So that's the meaning of secular constitution. And if you remember, in 1994, in one of the important cases decided by the Indian Supreme Court, S.R. Bommai versus Union of India. So in this case, S.R. Bommai versus Union of India 1994, Justice B.P. Jeevan Reddy said, secularism is a basic feature of the Indian Constitution. Secularism is a basic feature of the Indian Constitution, which means secularism cannot be taken away from the Indian Constitution, even by the Indian Parliament, by amending the Constitution under Article 368. Remember, the term secular was added to the Indian Constitution in 1976 by the 42nd Amendment. So before 1976, in the preamble, there was no term with the name secular. Indian preamble says socialist, secular and a democratic republic. So the term secular is inserted in the Indian preamble in 1976 by the 42nd Amendment. Does that mean that before 1976 Indian Constitution was not secular? No. So before 1976 it was implicit, it was hidden. See, Article 14, equality before law. Article 15, prohibition of discrimination. Article 19, 1, class 1, subclass A, fundamental right to freedom of speech and expression. Article 21, fundamental right to life and liberty. Article 25, fundamental right to freedom of religion of individuals. Article 26, fundamental right to freedom of religion of religious denominations. Article 30, religious and linguistic minorities have the fundamental right to establish and administer educational institutions of their choice. All these articles in the Indian Constitution have ensured that Indian Constitution is secular. So despite not having the term secular in the preamble, even before 1976, Indian Constitution no doubt was very secular. But what is implicit, what was hidden, was made explicit in 1976 through the 42nd Amendment. So what the 42nd Amendment has done is, what is already available in the Constitution of India was declared in clear terms. So the term secular was added to the Indian preamble in 1976 through the 42nd Amendment. So that's one more important salient feature of Indian Constitution. Then, see, the term secular state mean establishment of a theocratic state is prohibited. Establishment of a theocratic state, which means a state which promotes, sponsors one particular religion. A theocratic state means a government which promotes and patronizes one particular religion. So establishment of such a theocratic state is prohibited under the concept of secularism. Equal treatment to all religions. Encroachment of religion into secular activities is prohibited. In matters of religion, state has no place. That's about one salient feature of the Indian Constitution, that is secularism. Then, independent judiciary with power of judicial review. See, remember, there is a basic difference between Indian Constitution and American Constitution with respect to organization of judiciary. In America, the judiciary of the states is independent of the judiciary of the federal government. In America, the judiciary of the states is independent of the judiciary of the federal government, the federal constitution. See, the Supreme Courts in all the 50 states in America, they don't come under administrative control of the American Supreme Court. But in India, we had integrated judiciary. The same set of courts for the center as well as the states. The Supreme Court exercises administrative control over the high courts. High court exercises administrative control over the lower courts. So there is no division of judicial power between the center and the states. So this is called integrated judiciary. And in India, as the constitution is written, And if the constitution is written, constitution is supreme. And to protect the supremacy of the constitution, and to protect the federal nature of the Indian constitution, to protect the fundamental rights guaranteed to the citizens of this country, Indian constitution has provided for the establishment of independent judiciary. And this independent judiciary has the power of judicial review. What do you mean by power of judicial review? The actions of the executive branch and the actions of the legislative branch, they have to be in conformity with the Constitution of India. Any action of the executive branch, any action of the legislative branch, if it is against the Constitution of India, if it is against the fundamental rights, they can be struck down by the Indian Supreme Court and the High Court. So Indian Constitution provides for independent judiciary. How do you say that the judiciary is independent? Once the judges of the Supreme Court and High Court are appointed, their removal is very difficult. You need special majority in the parliament for removing a judge of High Court and Supreme Court. Very difficult to remove the judges of the Supreme Court and High Court. So they are guaranteed security of tenure. In that sense, the judiciary is independent. So once the judges of the Indian Supreme Court and the judges of the High Court are appointed by the President on the advice of the collegium, their removal is not in the hands of the executive branch. Their removal can be done only by the parliament, that too with special majority. Getting special majority is very difficult. In the last more than 6 to 7 decades, not even a single judge is removed from the office. So the security of tenure guaranteed by difficult removal results in independent judiciary. So this independent judiciary exercises control over the executive branch and the legislative branch through its power of judicial review. So in all the countries with federal constitutions, in all the countries with a written constitution, usually the judiciary will be independent to uphold the supremacy of the written constitution, to resolve the conflict between the central government and state government. The power to interpret the provisions of the Constitution and to enforce the fundamental rights guaranteed to the citizens of India, we need an independent judiciary. So the Indian judiciary is truly independent. The independence is guaranteed by security of tenure, difficult removal. The judiciary exercises control over the executive and legislative branches. And the judiciary ensures that the executive and legislature, they work in conformity with the provisions of the Indian Constitution. So that's about the independent judiciary and integrated judiciary. Remember, even independent judiciary was considered to be one of the basic features of the Indian Constitution, which means the independence of judiciary cannot be altered by the Indian Parliament, even by amending the Constitution under Article 368. Independent judiciary is a basic feature of the Indian Constitution. Then emergency provisions. See, there are three kinds of emergencies under Indian Constitution: national emergency, state emergency. State emergency is also called president rule or constitutional emergency. Then financial emergency. To overcome certain difficult situations or emergency situations and to protect the unity and integrity of India, Indian Constitution has provided for emergency provisions. See, emergency provisions, they can be utilized by the government, national government, to protect the unity and integrity of India in case of threat of war, threat of external aggression. And when emergency is declared, especially when national emergency is declared, Indian Constitution becomes unitary. The center becomes all powerful. So the purpose of emergency provisions is to protect the unity and integrity of India in terms of crisis situations. So the emergency provisions can be imposed only for a temporary period to deal with a crisis situation. Once the situations become normal, emergency has to be withdrawn, normalcy has to be restored. So emergency provisions to protect the unity and integrity of India in terms of crisis is again a salient feature of Indian Constitution. Then, see, if you broadly make a comparison between Indian Constitution with America, American Constitution has provided for judicial supremacy. In America, among all the three branches of the government, executive branch, legislative branch and judicial branches, judiciary is very powerful. American Constitution is based on the principle of judicial supremacy. And if you take the Constitution of United Kingdom, among all the three branches of the government in United Kingdom, executive branch, legislative branch, judicial branch, legislature is very powerful, parliament is very powerful. So Constitution of Britain is based on parliamentary supremacy. And if you take French Constitution is based on executive supremacy. In France, among all the three branches of the government, executive, legislature and judiciary, executive is very powerful. So American Constitution is based on judicial supremacy. British Constitution is based on parliamentary supremacy. French Constitution is based on executive supremacy. Then what about Indian Constitution? See, the framers of the Indian Constitution tried to borrow parliamentary supremacy from Britain, judicial supremacy from American Constitution. So we tried to synthesize, merge both concepts from Britain and America. So synthesis of parliamentary democracy, parliamentary sovereignty and judicial supremacy. Synthesis of parliamentary sovereignty and judicial supremacy. See, remember, the framers of the Indian Constitution, the fathers of the Indian Constitution, they were silent on the issue that if there is a difference of opinion between the Supreme Court and Indian Parliament, who shall have the final say? Who shall have the final say? Remember, the supremacy of the written Constitution is protected by the Indian Supreme Court through its power of interpretation. But that written Constitution can be amended by the Indian Parliament under Article 368. So the Constitution is silent on who is between the Parliament and the Supreme Court. But the way the Indian Constitution is worked out over a period of time, it has led to the emergence of Supreme Court as the most powerful branch, not only in India, even across the globe. So today in India, we had a situation wherein among all the three branches of the government, executive branch, legislative branch and judicial branch, judiciary is very powerful. So that's why some people have written articles like Pratap Banu Mehta, a political thinker in India, has written articles on judiciary saying, judicial sovereignty, in any democracy, sovereignty resides with the people, with the politicians, but in India, the supreme power resides with the Indian Supreme Court. So Indian Supreme Court, through its power of interpretation, has coined certain new doctrines called the doctrine of basic structure. It has also coined the terms like collegium and have took away the powers, the legitimate powers of the executive and legislative branches. Executive and legislative branches. Through the doctrine of basic structure, the unlimited power of the Indian Parliament to amend the Constitution is made limited. And by coining the term collegium, the power of the executive to participate in the appointment of the judges of the Supreme Court and High Court was taken away. So in this way, the judiciary emerged powerful, the Supreme Court emerged powerful. So, though Constitution of India is silent on the issue of which is supreme, either Parliament or the Supreme Court, the way the Constitution of India is worked out and because of the interpretations of the Indian Supreme Court, today in India we have judicial supremacy. Among all the three branches of the government in India, executive branch, legislative branch and judicial branch, the judiciary is supreme. That's one more salient feature of the Indian Constitution. Then the concept of fundamental duties. See, the citizens shall have not only fundamental rights, but they shall also have fundamental duties. Remember, the concept of fundamental duties, it was not there in the original Constitution of India, which came into implementation on 26th January 1950. So the idea of fundamental duties, the concept of fundamental duties were inserted in the Constitution of India in 1976 through the 42nd Amendment on the recommendations of Swaran Singh Committee. On the recommendations of Swaran Singh Committee in 1976, the Constitution was amended, and this 42nd Amendment has inserted fundamental duties under Part 4A, under Article 51 capital A, under Article 51 capital A. So there are 11 fundamental duties which are imposed on all the citizens of this country. For example, it is the fundamental duty of every citizen to renounce the practices which are derogatory to the dignity of women. It is the fundamental duty of every citizen to protect the sovereignty, unity and integrity of India. Like this, the Indian Constitution provides for a set of 11 fundamental duties on the citizens. So the citizens not only have fundamental rights, but they shall also have got fundamental duties to be performed by them. So they were inserted in the Indian Constitution in 1976 through the 42nd Amendment. And the idea of fundamental duties, it is borrowed from the then USSR, the Constitution of USSR, the present day Russia. So this is one more salient feature. Then universal adult franchise. Universal adult franchise. The right to vote to all the citizens. The right to vote to all the citizens irrespective of religion, ethnicity, gender. Remember, even in United Kingdom, it took centuries for the women to get equal right to vote on par with men. Even in America, from day one, that is from 1789, from the day one of the implementation of the Constitution of America, the women do not have the right to vote. But unlike America, unlike Britain, in India, all the citizens, irrespective of race, ethnicity, religion, gender, they are given the equal right to vote, which we say universal adult franchise, equal right to vote, political equality, promoting political equality. So the salient feature of universal adult franchise says equality among all the citizens. Equality among all the citizens. So the universal adult franchise upholds the principle of equality. Upholds the principle of equality. Then one more salient feature of the Indian Constitution is single citizenship. See, ideally in all the classical federations, like in America, there is a dual citizenship. A person is citizen of the American nation state and he is also a citizen of one of the states in America. But the framers of the Indian Constitution, despite Indian Constitution being federal, they have went in for a single citizenship. Indian Constitution provided for single citizenship despite it being a federal constitution. The reason is the wisdom of the framers of the Indian Constitution. So the framers of the Indian Constitution felt that single citizenship will promote sense of brotherhood. Single citizenship will promote the sense of unity and oneness among the people of this country. This might help in protecting the unity and integrity of India. So that is the reason why single citizenship was provided for under the Indian Constitution, despite Indian Constitution being federal. Then, see, the Indian Constitution is again unique in the sense that it has provided for the establishment of independent constitutional authorities. For example, if you take Election Commission of India. So, Election Commission of India is one of the independent constitutional authorities provided for in the Indian Constitution. Election Commission of India has got global reputation for conducting free and fair elections. So it is because of the role of the Election Commission of India, democracy in India sustained. Democracy in India became success. One reason is the role of Election Commission of India. The role of Election Commission of India in conducting free and fair elections. So the success of Indian democracy, one reason is the extremely stellar role played by the Election Commission of India. And then why do we say independent? See, the Chief Election Commissioner, though appointed by the executive branch of the government, he can be removed only by the Parliament through special majority. Once appointed, the Chief Election Commissioner cannot be removed by the executive branch. He enjoys security of tenure. So this independence has led to very good functioning of the Election Commission of India, and in conducting free and fair elections, Election Commission of India has played an important role because of independence which is guaranteed to it. So creation of such independent constitutional authorities was one of the novel features of the Indian Constitution. In addition to Election Commission of India, Finance Commission of India is also a constitutional authority, an independent constitutional authority. Remember, Finance Commission of India plays an important role in recommending to the Union government to devolve its tax revenues to the state governments to address vertical imbalances. What do you mean by vertical imbalance? See, the framers of the Indian Constitution, to protect the unity and integrity of India, have made the central government very strong. I told you that. So the revenue raising capacity of the central government is very high. The revenue raising capacity of the state governments is limited. But the developmental responsibilities of the state governments are very high. For example, health, agriculture, rural development, drinking water, sanitation, they all need lot of money. They are in the state list. But there is not enough money with the state governments. So the framers of the Indian Constitution have created vertical imbalances. States have more responsibilities, little money. So to address these vertical imbalances, they have also provided a solution. The solution is Finance Commission of India. Finance Commission of India acts as a balancing wheel in the center-state financial relations. The tax revenues of the central government, they are shared with the state governments on the recommendations of the Finance Commission of India. For example, recently the 14th Finance Commission has recommended 42% of the tax revenues of the central government to be shared with the state governments. So, Finance Commission of India plays an important role in promoting cooperation between the central and state governments. Finance Commission is an example for cooperative federalism. The center and the states cooperating with each other. The center supporting the state governments with more money from itself. Then Comptroller and Auditor General of India. See, the expenditure made by the governments, both central as well as the state governments, is taxpayers' money. You and me pay a lot of taxes. This money is spent for the welfare of the citizen by the central government as well as the state governments. So the expenditure made by the central government and the expenditure made by all the state governments, it is verified. It is verified by Comptroller and Auditor General. So Comptroller and Auditor General acts as the guardian of public purse. And remember, Comptroller and Auditor General is again appointed by the Union government, but his removal is in the hands of the Parliament. Once appointed by Union government, he has security of tenure. He cannot be removed by the executive branch. So in India, Comptroller and Auditor Generals have played an important role in making the governments accountable by exposing inefficiency in public spending and corruption in public spending. So CAG is again an example for an independent constitutional authority. And that's one more salient feature of Indian Constitution. Then Public Service Commissions. So we have Union Public Service Commission, Joint Public Service Commission, State Public Service Commissions. So these service commissions play an important role in recruiting the civil servants on merit basis. Merit-based recruitment. Merit-based recruitment is made possible by independent constitutional public service commissions in India. Union Public Service Commission, State Public Service Commissions, Joint Public Service Commissions. So though the members of these public service commissions are appointed by the Union government, they cannot be removed straight away by the Union government. There shall be an inquiry conducted by the Supreme Court. Only if the inquiry proves that there is some corruption in the members of the Public Service Commission, then only the Union government can take up the removal of the members of the Public Service Commission. So they are guaranteed security of tenure. So, like this, Indian Constitution has provided for the establishment of independent constitutional authorities which have played an important role in conducting free and fair elections, in promoting cooperative federalism, in merit-based recruitment, as well as in making the public spending very efficient. So that's one more salient feature. Then, so let's continue our discussion. See, the other salient feature of Indian Constitution is, Indian Constitution was called as borrowed Constitution. See, B.N. Rao was the constitutional advisor to the Constituent Assembly. So B.N. Rao has studied around 60 constitutions across the globe, and after having studied those constitutions very carefully, those provisions which fit into Indian Constitution which fit into Indian conditions were borrowed, and they are suitably modified for Indian conditions. So it's not fair to make a criticism that Indian Constitution is a borrowed constitution and it is a Xerox copy of several other constitutions. No, we didn't blindly borrow the provisions in the present constitution from other constitutions right away. So the other constitutions were thoroughly studied. Whatever fits into Indian constitution, whatever fits into Indian conditions, they were borrowed and they were suitably modified to suit to the Indian constitution. So of course Indian Constitution is a borrowed constitution, but it is not a blind copy of the provisions in other constitutions. They were carefully considered, carefully modified to suit to Indian genius and Indian conditions. So now we will see what are the features in the Indian Constitution which are borrowed from different countries across the globe. For example, if you take United Kingdom, I told you that India was under the British rule for a very long time. So India was very much influenced by the Constitution of Britain. So what is borrowed from Britain is the following things. See, parliamentary democracy, the idea of parliamentary democracy in India is borrowed from the Constitution of Britain. I told you that parliamentary democracy, there is a fusion of executive and legislative branches. Parliamentary democracy is much more accountable. In parliamentary democracy, the political power can be shared. The diversity can be better accommodated. So this is one principle which is borrowed into Indian Constitution. From United Kingdom, we borrowed parliamentary democracy. Then the concept of rule of law. So Article 14 of the Indian Constitution provides for equality before law. And this equality before law includes rule of law as well. And I have already told you in the previous lecture that it is A.V. Dicey who gave the concept of rule of law in Britain. So even the Indian Constitution does contain the principle of rule of law. This is borrowed from Britain. It got developed in Britain. Then legislative procedure. See, any bill which is introduced in Indian Parliament, it will be read 3 times. First reading, second reading, third reading. So in the first reading, the general objectives of the bill are read out. In the second reading, the detailed provisions of the bill are discussed, debated and subjected to amendments. In the third reading, whether the bill will be totally accepted or totally rejected. So this is the procedure which is to be followed when the bills are introduced in the parliament. And this procedure which is there in India is borrowed from Britain. So the legislative procedure which is being followed in India in the parliament as well as in the state legislatures is borrowed from Britain. So along with parliamentary democracy, along with rule of law, even legislative procedure it is borrowed from Britain. Then I told you about single citizenship. Single citizenship is one of the salient features of the Indian Constitution. So this is borrowed from Britain. So Britain provides for a unitary constitution, not a federal constitution. So India, despite being federal, we provided for single citizenship, which is borrowed from Britain. This is to promote unity and integrity of India. And then cabinet system of government. The executive power conferred on a group of individuals called cabinet system of government. And the decisions have to be taken by the cabinet collectively. So the principle of collective responsibility, the principle of cabinet system of government, we borrowed from Britain. Then parliamentary privileges. In India, there are certain rights which are available only for the members of the parliament and for the members of the state legislatures. They are not available for the ordinary citizens. So these special rights which are available to the members of the parliament, for the members of the state legislatures, which are not available to the ordinary citizens, they are called privileges, parliamentary privileges. For example, for whatever being spoken by a member of parliament in the parliament on that speech, even if it is a defamatory, brings down the dignity of an individual, no defamation law can be filed in a court of law. Criminal defamation laws cannot be filed in a court of law on a member of parliament or a state legislature for anything what he has said or spoken in the parliament or the state legislature. This is one privilege. To give an example, so the idea of parliamentary privileges are the special rights which are available to the members of the parliament and state legislatures. This is again borrowed from Britain. In addition to this, bicameral parliament. Indian parliament is bicameral. Indian parliament contains 2 houses. Lok Sabha, lower house. Rajya Sabha, upper house. See, for India, the Indian parliament is made bicameral to protect the interests of the state governments. Indian parliament, the upper house is Rajya Sabha. Rajya Sabha is also called the Council of States. So in the Rajya Sabha, the states are represented. The MLAs, the members of legislative assemblies, they elect the members of the Rajya Sabha. So Rajya Sabha is the representative of the state government. So Indian parliament is bicameral. Lower house is Lok Sabha, upper house is Rajya Sabha. And even British parliament is bicameral. The lower house in Britain is called British House of Commons. The upper house in Britain is called House of Lords. House of Lords is hereditary. Rajya Sabha not hereditary. Some members are nominated. Some members are indirectly elected. So this concept of bicameral parliament or two houses in the parliament, it is borrowed from Britain. In addition to these, prerogative writs. I told you that for enforcing the rights of the citizens in India, the citizen can file writ petitions before the Supreme Court, before the High Courts under Article 32 and Article 226 respectively. So this idea of writs is again borrowed from Britain. So these are the features which we borrowed from Britain to Indian Constitution. Parliamentary democracy, rule of law, legislative procedure followed in the parliament and state legislatures, the idea of single citizenship, cabinet system of government, prerogative writs, parliamentary privileges and bicameral parliament. And if you take United States of America, what is that we have borrowed from USA? The concept of written fundamental rights borrowed from America. Independent judiciary with the power of judicial review, again borrowed from America. The office of Vice President in India borrowed from America. So if a vacancy arises in the office of the President, the Vice President will act as the President. He also acts as the presiding officer of the upper house, that is Indian Rajya Sabha. Same is the case in America. The Speaker of the Senate, see, American Parliament is bicameral. The lower house is House of Representatives. The upper house is Senate. So the presiding officer of the Senate is Vice President of America. And this Vice President of United States of America will occupy the office of the President if a vacancy arises in the office of the President. So the office of the Vice President in India is borrowed from the office of the Vice President in United States of America. In addition to these, the procedure for removing the President of India, the procedure for removing the Judge of High Court and Judge of Supreme Court, it is again borrowed from America. See, for removing the President of India, you need an impeachment motion to be passed by Lok Sabha and Rajya Sabha separately by 2/3 of the total strength. This is borrowed from America. And for removing a Judge of Supreme Court and a Judge of High Court, you need to pass a removal motion in the Parliament by the Lok Sabha and Rajya Sabha by special majority, a combination of absolute majority plus 2/3 of the members present and voting. So this is again borrowed from America. In addition to this, the concept of independent judiciary. So these are the features which we have borrowed from United States of America. Fundamental rights, independence of judiciary with the power of judicial review, procedure for impeaching the President, removal of the Supreme Court and High Court judges, and office of the Vice President. Then if you take Irish Constitution, so the idea of directive principles of state policy, that is, I told you that directive principles of state policy, they are positive obligations on the Indian state to achieve welfare state. This is borrowed from the Constitution of Ireland, the idea of directive principles of state policy. In addition to that, in the upper house in the parliament, which is called Rajya Sabha, some of the members are nominated, some are indirectly elected. Rajya Sabha is composed of 245 members, out of which 12 are nominated. The remaining are indirectly elected. So the nomination of members to Rajya Sabha is done by the union government, by the president on the advice of the union government. So this is borrowed from the Constitution of Ireland. So nominating the members of Rajya Sabha by the president on the advice of the union government is borrowed from Irish Constitution. And then the method of election of president. The president is elected by proportional representation by single transferable vote. The election of the president in India is based on proportional representation by single transferable vote. This is also borrowed from the Constitution of Ireland, Irish Constitution. Then Constitution of USSR. See, I told you that the fundamental duties were inserted in the Indian Constitution in 1976 through the 42nd Amendment. So they were borrowed from the Constitution of USSR, the idea of fundamental duties. And even the Indian preamble speaks about social, economic and political justice. Even Article 38 of the Directive Principles of State Policy also speak about social, economic and political justice. So the idea of social, economic and political justice is again borrowed from the Constitution of USSR. And then if you take France, the idea of republic, Indian constitution is a republican constitution. So what do you mean by a republic? The head of the state is elected. He could be directly elected or indirectly elected. France is a republic. USA is a republic. India is a republic. But in France, the French president, who is the head of the French nation state, is directly elected. In India, in America, the president is indirectly elected by an electoral college, but they are elected. So a constitution where the head of the nation state is elected is a republican constitution. On the contrary, in Britain, the head of the nation state the head of the nation state is hereditary. So Britain is not a republic. Britain had constitutional monarchy. Britain had constitutional monarchy. So this idea of a republican constitution where the head of the nation state is elected is borrowed from French constitution. France is also a republic. In addition to this, the ideals of liberty, equality and fraternity, which were very popular at the time of French Revolution in 1789. The French Revolution of 1789 was inspired by the ideals of liberty, equality and fraternity. So the same were included in the Indian preamble. So the idea of liberty, equality and fraternity, which finds a mention in the Indian preamble, is borrowed from the Constitution of France. Then, procedure established by law. There are two concepts called due process of law and procedure established by law. American Constitution is based on due process of law. Under due process of law, the judiciary is very powerful. Under procedure established by law, the judiciary enjoys less powers compared to due process of law. So Indian Constitution provided for procedure established by law, and this is borrowed from Japanese Constitution. But in Menaka Gandhi versus Union of India in the 1980s, Indian Supreme Court has borrowed the American concept of due process of law even into Indian Constitution. So the original Constitution of India, which came into implementation on 26th January 1950, provided for procedure established by law. But in 1980s, the Indian Supreme Court in Menaka Gandhi versus Union of India has borrowed the American concept of due process of law into Indian Constitution, Japan. Then South Africa. So the Constitution of South Africa, from the Constitution of South Africa, we have borrowed the procedure for amendment of Constitution. And I told you the members of the Rajya Sabha, some are nominated, this is borrowed from Ireland. The other members of the Rajya Sabha, they are indirectly elected by the members of the legislative assemblies. This is borrowed from the Constitution of South Africa. So the indirect election of the members of the Rajya Sabha is borrowed from South African Constitution. Then remember, Government of India Act 1935 also has played an important role in framing the present Indian Constitution. More than 50% of the Indian Constitution is taken from Government of India Act 1935. Government of India Act 1935, enacted by the British Parliament, forms the foundation on which the Indian Constitution is built. So the existing emergency provisions in the Indian Constitution, they are borrowed from the existing provisions in the Indian Constitution, they are borrowed from Government of India Act 1935. And I told you that we had public service commissions. Which help in merit-based recruitment, again borrowed from Government of India Act 1935. Office of Governor, borrowed from Government of India Act 1935. Federal Scheme, Division of Powers, again borrowed from Government of India Act 1935. See, from Canada, so I told you that Indian Constitution provided for a strong center with relatively weak states. So this idea of a federal constitution with a strong center and with relatively weak states, this is borrowed from Canadian Constitution. Strong center, relatively weak states. And in America, under the American Constitution, the residuary power goes to the state governments. But under Canadian Constitution, the residuary power goes to the center. What do you mean by residuary power? The residuary power refers to the items of administration which are not mentioned in the which are not mentioned in the constitution. The subjects of administration which do not find a mention in the constitution, they go to the states in America, but they go to the center in Canada. This we have borrowed from Canadian constitution. In India, under the Indian constitution, the residuary powers which are not mentioned in the constitution of India, they go to the central government and to the Indian parliament. This is borrowed from Canada. Then, advisory jurisdiction of the Supreme Court. See, the union government can seek the authoritative opinion of the Supreme Court on several issues through the President of India under Article 143. Under Article 143 of the Indian Constitution, the union government through the President of India can seek the advice of the Indian Supreme Court on certain important issues. This is called advisory jurisdiction of the Indian Supreme Court. This is borrowed from Canadian Constitution. The American Supreme Court doesn't have advisory jurisdiction. Then, in India, the governors are appointed by the central government. The President of India, on the advice of the union government, will appoint the governors, and he is also the removal authority. So, such appointment of governors by the central government is borrowed from Canadian Constitution. Then, Australia. So, what is that we have borrowed from Australia? Concurrent list. So, 7th schedule of Indian Constitution provides for 3 lists. List 1, union list. List 2, state list. List 3, concurrent list. On all the items in the concurrent list, Parliament can make laws, state legislatures can also make laws. But if there is a conflict between the law made by the Parliament and the laws made by the state legislatures, the law made by the Parliament will be supreme. So the idea of concurrent list where the center and the states can make laws, this is borrowed from Australian Constitution. Again, if there is a disagreement between the Lok Sabha and Rajya Sabha with respect to an ordinary bill, there is provision for joint sitting. So in case of disagreement, difference of opinion between Lok Sabha and Rajya Sabha, there is a provision for joint sitting. And this is borrowed from Australian Constitution. So joint sitting in case of disagreement between Lok Sabha and Rajya Sabha is borrowed from Australian Constitution. In addition to this, freedom of trade, commerce and intercourse, especially interstate trade and commerce, the idea of freedom for interstate trade and commerce, this is borrowed from Australian Constitution. So Indian Constitution does speak about freedom of trade, commerce and intercourse. This idea is borrowed from Australian Constitution. Then Weimar Constitution of Germany. Weimar Constitution of Germany is framed after the Second World War. And the idea of suspending the fundamental rights during emergency is borrowed from Weimar Constitution of Germany. The idea of suspending the fundamental rights at the time of emergency is borrowed from Weimar. Weimar is the place where the German constitution was drafted after Second World War. So Weimar Constitution of Germany, suspension of fundamental rights during emergency. The idea of suspension of fundamental rights during emergency is borrowed from Weimar Constitution of Germany. Weimar Constitution of Germany. Then the other important salient feature of Indian Constitution is the idea of all India services. See, in classical federations like America, there are no services which are common to the center and the states. The federal government has got its own bureaucracy to enforce the federal laws. The states have got their own bureaucracy to enforce the state laws. But in India, there are certain services which are common to the center and the states, which are called all India services. The central government has got its own bureaucracy, the states have got its own bureaucracy. In addition to the central services and state services, there are certain services which are called all India services. In India, Indian Administrative Service, Indian Police Service, Indian Forest Service, these are the 3 all India services. What is the reason why India went in for an all India service? As I told you, the framers of the Indian Constitution were greatly worried about protecting the unity and integrity of India. So they have included under Article 312 a provision, for establishment of all India services. All India services are common to the center and the states. They are recruited by the Union Public Service Commission, appointed by the Union government and allocated among the states. They are available for the central government as well as the state governments. As they are recruited by the Union Public Service Commission and they are appointed by the President of India, they have more loyalty to the union government. They cannot be removed by the state government. They cannot be dismissed by the state government. So their removal and dismissal is in the hands of the union government. So in every state, 50% of the All India Service Officers, they are from the same state, and 50% are from outside the state, outsiders. So if there is some secessionist effort in a particular state, for example in Punjab once there were Khalistan movement. So if any state wants to make efforts to break away from the Indian Union, the All India Service Officers who are outsiders in that particular state, who are loyal to the union government, they act as eyes and ears. They report to the union government with respect to any effort which is being made which poses a threat to the unity and integrity of India. That is the reason. So the reason why we need All India services in India is to protect the unity and integrity of India. That's one purpose. The other purpose is All India Service Officers are recruited through an All India competitive examination. So the best and the brightest across the country are chosen, and they occupy all the key important positions in the central and the state governments. So they play an important role in ensuring the standards of administration throughout the country. That's one more reason why we had All India services. Remember, in America there are no services which are common to the center and the states. That is a unitary feature. Remember, American Constitution is an example for a true federation. In all the true federation, the states are very powerful. The center is relatively weak. And All India services in India, they are a tool in the hands of the union government over the state government. So it is a unitary feature. So All India services are those services which are common to the center and the states. The reason why we have All India services is to protect the unity and integrity of India, to ensure the standards of administration throughout the country. Then, principle of constitutionalism. What do you mean by the principle of constitutionalism? See, principle of constitutionalism refers to limited government. If there is a written constitution, and in the presence of a written constitution, all the three branches of the government, executive branch, legislative branch, and judicial branch, they have to work within the limits of the constitution. So to ensure that the government doesn't become dictatorial, to ensure that the government doesn't become despotic, to ensure that the government doesn't become arbitrary and irrational, the constitution, the written constitution through the judiciary will exercise check over the executive and legislative branch. So this is the idea of constitutionalism. So the term constitutionalism refers to a limited government. So the government will be subjected to control. The government will not be permitted to use arbitrary powers. So it is through the judiciary, the independent judiciary with the power of judicial review will exercise control over the executive branch and the legislative branch, and will ensure that these branches will act in conformity with the Constitution of India. So this idea of a limited government in the presence of a written constitution, in the presence of independent judiciary with power of judicial review, is called constitutionalism. So in one of the cases in 2007, in I.R. Coelho versus State of Tamil Nadu, I.R. Coelho versus State of Tamil Nadu, this case relates to the immunity enjoyed by the 9th schedule. As part of the judgment on 9th schedule in 2007, in I.R. Coelho versus State of Tamil Nadu, Indian Supreme Court said, control over the exercise of the government power is necessary to protect democracy. Exercising control over government power is necessary to protect democracy, and this can be done through independent judiciary, through power of judicial review. So judicial review is the instrument of constitutionalism. Judicial review is the tool through which the government powers are regulated, they were limited. And Indian Constitution is an example for constitutionalism. Indian Constitution is written, Constitution is supreme, and all the three branches of the government, they have to conform to the written Constitution. So the executive and legislative branches, they are controlled, they are limited by the independent judiciary through the power of judicial review. So the government is not allowed to become despotic, arbitrary, unreasonable. So that is the idea of limited government. Constitutionalism refers to limitations on the government by the written constitution through independent judiciary, through the power of judicial review. Then, unlike American Constitution, even Indian Constitution, unlike American Constitution, Indian Constitution provides for cooperative federalism. This is absent in American Constitution. the sovereignty is divided between American Federation and the states, and there were no mechanisms in place in American Constitution for the federal government and the state governments have to cooperate with each other. Unlike American Constitution, Indian Constitution has provided for cooperative federalism. For example, I told you about Finance Commission of India. Under Article 280 and 281, the Finance Commission of India will try to address the vertical imbalances between the center and the states. The tax revenues of the central government are shared with the state governments to assist the state governments to fulfill their developmental responsibilities on the subjects in the state list. This is an example for cooperative federalism. And then Interstate Council, Article 263 provides for Interstate Council. Interstate Council acts as a platform for resolving the issues which are common to the center and the states. Again, a very good example for cooperative federalism. And in the recent past, the 101 amendment to the Indian Constitution has provided for the establishment of GST Council. Article 279 capital A. Article 279 capital A provides for cooperative federalism in the financial sphere. With respect to goods and service tax, the central government and the state governments together will decide. An example for shared sovereignty, pooled sovereignty. In classical federations like in America, the sovereignty is divided between the center and the states. But Indian Constitution provided for pooled sovereignty, shared sovereignty. The political power of the center and the states, the sovereign power of the center and the states is exercised together in the collective interest. A very good example in the recent past is GST Council. In the GST Council, the center is represented, the states are represented. The center and the states together will decide the matters relating to goods and services tax. The center is not giving up its sovereignty, the states are not giving up their sovereignty, but the sovereignty is pooled, it is a shared. The center and the states together exercise the sovereignty with respect to goods and service tax. An example for pooled sovereignty or shared sovereignty. An example for cooperative federalism. So Indian Constitution is again distinct in the sense that it has provided for cooperative federalism. It has provided for the center and the states to cooperate with each other on several issues through Interstate Council, through Finance Commission, through GST Council. This is again a salient feature of the Indian Constitution. So that's it about the salient features of the Indian Constitution. Thank you.